This is the first meeting of the Bills Committee. Let's invite the public officers to come inside the conference room. I have other commitments today, unfortunately, so I have to leave early. We do not have a deputy chairman for the Bills Committee. And I want to make sure progress of the Bills Committee is maintained. That's why I'll ask Mr. Andrew Lam to continue to preside over the meeting after I have left the meeting. Do members have any objections? If not, that's what we'll do. Thank you, Mr. Lam, for your accommodation. Let's proceed with the meeting. Again, let's invite the public officers to come in and take a seat. Before I invite the Permanent Secretary to speak, I would like to hear from members on whether we need to invite public submissions, be it in written form or oral form, that is a public hearing, whether it should be conducted. Ms. Doreen Kong. Chair, the bill is relatively technical, so my suggestion is that we should invite written submissions, especially those from professional bodies. Any other comments from members? All right, if not, we will not hold a public hearing, but will invite public submissions. The Secretariat will later post a notice on the LegCo website inviting public submissions on the bill. Once the submissions have been received, they will be circulated for members' reference. Let's first invite the administration to brief members on the bill. After the presentation, it would be the Q&A session. How long will the presentation be? I think approximately 15 minutes. Thank you, Chair. Before I give the floor to Frank, the Deputy Secretary, to give the presentation, I will give a brief introduction. I would like to thank the Chairman and members for joining the Bills Committee to scrutinize the bill, that is the extension of government leases bill. I will give you some background information. As you know, under the existing mechanism, the extension of a government lease would require execution of a new lease through contractual means. The Lands Department would have to sign with all owners a new lease. Before the handover, we have, after the handover, we have 20 odd leases that have been extended. In our experience, the process would take long. Seeing that we think that we may not be effectively cope with the significant number of leases expiring from 2025 onwards. That's why we propose that by operation of law, we will extend the leases expiring from June 2025 onwards. We would like to adopt this mechanism to bring certainty to owners, investors, and other stakeholders regarding lease extension matters. We would also like to instill confidence in them. We have consulted different bodies, including the legal sector, the real estate sector. They have expressed their support, and in May of last year, we have consulted the panel on development. to talk about the framework of the legislative amendments, we have incorporated the feedback given by members then in the legislative amendments we propose now. I'll now give the floor to Frank, the Deputy Secretary, to give more details about the bill. Deputy Secretary, please. Thank you, Chair. As the Permanent Secretary said, we want to streamline lease extension. We will publish Gazetted notices to extend leases by operation of law. We need to effectively cope with the significant number of leases expiring from 2025 onwards. Our policy is clear. We have based our policy on the 1997 land policy, and this will remain the government's prerogative after the legislative amendments have been implemented. It's just that the means of lease extension has been changed. We have 25 leases expired after the handover, and out of the 25 leases, only 2 were not extended because the relevant owners could not be found, and 1 pursued lease modification for redevelopment. The remaining 22 will all be extended. We have 2,400 lots that will expire from June 2025 to June 2047, the 29th. And on 30th of June 2047, we have leases of around 300,000 lots that will all expire on the same day. We do have a significant workload, as you can see. For the 1997 land policy, we would have the policy applicable to leases not containing a right of renewal, non-renewable leases, excluding short-term tenancies and special purpose leases. These will continue to be extended by contractual means due to their special considerations. The government will have sole discretion, but in general, the government will renew most leases unless there are special public interest considerations. For the applicable leases, they will be extended for a term of 50 years without payment of an additional premium, but an annual rent equivalent to 3% of the prevailing rateable value of the property at the time of assessment of the annual rate will be charged. As you can see here, the procedures of the existing mechanism are cumbersome. It is not feasible to deal with the large amount of leases to be extended in this manner. If we have, for example, multi-ownership with a multi-story building, for example, 200 owners, we have to sign a new lease with all 200 owners. It would also require the government first offering the terms and conditions. The owners would have to accept the terms and conditions. The owners would also have to submit documents to prove that they are the true owners. It would also involve the clearing of outstanding encumbrances, for example, undischarged mortgages under the original lease, and/or having them transferred to the new lease. The owners may have to pay some legal fees for the process. Under the existing mechanism, if there is multiple ownership, the new lease will first be granted to the Financial Secretary Incorporated (FSI) before assigning the undivided shares of individual properties from the FSI to the relevant owners, so that owners who are able to complete the assignment procedures will not be affected by those who fail to do so. In fact, in 2006, for Port Fulam Garden, 1,600 owners would have to be involved, and the signing of the new lease with all 1,600 owners took 3 years. Under the new mechanism, we will have a new primary legislation to provide for a statutory standing mechanism so that the Director of Lands will publish extension notices regularly in the Gazette to extend leases instead of executing new leases with owners. We have made reference to the new Net Territories Leases Extension Ordinance, that is Chapter 150, on how it gave legal effect to extension of new territories leases. We have consulted the panel on development in May of last year regarding the framework. We have also conducted exchanges with stakeholders, including the Hong Kong Association of Banks, Hong Kong Institute of Surveyors, Hong Kong General Chamber of Commerce, and so on. The sectors were generally in support of the framework. After the announcement of the bill on 7th of December, various sectors again expressed their support. Let me talk about the salient points of the bill. Regarding application, in accordance with 1997 land policy, we will cover all leases not containing a right of renewal that is non-renewable leases, excluding short-term tenancies and special purpose leases. And for special purpose leases in particular, Director of Lands is to cause an SPL, special purpose leases identification note, to be made in the land registry, LR register for an SPL. And for short-term tenancies and special purpose leases, they will continue to be extended by contractual means as they are under the conventional mechanism. The Director of Lands will, as I said, regularly publish extension notices in the Gazette specifying leases under a specific expiry period will be extended unless they are included in the non-extension list. Simply put, we have adopted the negative listing approach. It will facilitate owners to see what leases are not extended, and it would facilitate the notification of such owners. It will avoid having to publish a long list of leases to be extended and risking any unintentional omissions. Regarding how much ahead the extension notices should be published, we now propose to be no less than 6 years before expiry. When we consulted the panel on development, we proposed no less than 3 years before expiry. Having heard from stakeholders, because certainty is wanted, that's why we have lengthened the lead time. We believe we have struck a balance with this proposal, allowing greater certainty about the arrangements, but also allowing the government as a landlord to take into account circumstances closer to lease expiry to consider whether to grant extension. As an illustration for leases expiring in 2031, The extension notice and the corresponding non-extension list will be published no later than 31st of December 2024. For leases expiring in less than 6 years' time, that is from 2025 to 2030, the extension notices and the corresponding non-extension lists are to be published on the appointed date, which is expected to be a day before end of June 2024, assuming the proposed legislation is enacted before mid-June 2024. Similar to Chapter 150, we have provided an option for the registered owners of a lease to opt out from lease extension. The owners are to deliver an opt-out memorandum to the land registry for registration within 1 year from the date of publication of the relevant extension notice, but we do not expect to see a lot of such cases.
On the terms and conditions of extension, basically the terms and conditions will be preserved, but we will add some more additional clauses. According to the 1997 land policy, there is a term of 50 years without payment of an additional premium, but an annual rent equivalent to 3% of the prevailing rateable value of the property at the time of assessment. But then we will also incorporate additional clauses to safeguard the enforcement right on the part of the government. For example, the power to enter and carry out inspection, compliance with the town planning ordinance and the buildings ordinance, and that the government can re-enter parts of the lots in the event of non-compliance with lease conditions. These will not cause additional burden on the owners who comply with the licensing conditions. These are not new additional clauses as they have been incorporated into the existing leases. On the interests, encumbrances, and rights, they will be carried forward. So some procedures can be streamlined, and the aim is to provide a streamlined and efficient manner or an orderly manner by way of legislation. There will also be clauses on foreign-related entities. These are not new clauses either. Since June 2022, the Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR, OCMFA, has already implemented these conditions. For chancelleries, residences of heads of missions and mission staff, before the expiry of the land lease, they have to obtain consent from the OCMFA in order for the lease to be extended. So the final decision is subject to the decision of the OCMFA. That is, the relevant unit has to apply for a permission from the OCMFA, and the period is 60 days before the expiry of the land lease. The law also provides that if the organization or a body does not or fails to obtain the agreement by the OCMFA, there will be consequences. That is, the land lease will not be allowed to be extended. If the premises are multi-story buildings, the interests will also be granted to FSI first before assigning the undivided shares of individual properties from the FSI to the relevant owners. That is to ensure these owners will not be affected. In the register of the land registry, a notice has to be made. This is my introduction. Thank you. Anything else? Our meeting will run for 2 hours. At present, 7 members have requested to speak. I believe there will definitely be a second round. So for the first round, question and answer included 5 minutes. First member, Ms. Doreen Kong. I'll have a short meeting in a moment, so thank you, Chairman, for allowing me to speak first. Thank you, Chairman. In 1997, there was the New Territories Leases Extension Ordinance. This bill is a little bit different, but I am particularly concerned about Clause 13. In Clause 13, you put in place some covenants. That is, the covenants are subject to many clauses. Some clauses are newly added from the New Territories Leases Extension Ordinance. I'd like to know the reason why there are so many new covenants compared with the ordinance back in 1997. Some small owners could not comply with these. In Clause 13, the owner has to undertake that there is no unlawful structures. Well, there are many multi-story buildings in Hong Kong. For example, when there are 100 units in a building, I live in Unit 13A. How do I know if there are any illegal structures in Unit 10A? I've taken a look at bracket C for many times. But if I were a unit owner, well, I simply could not undertake. For example, in Red Hill Peninsula, I cannot say for sure whether any unit trespasses onto any government land. In C, the extension subject to the covenant and conditions. It's a condition that is failing this, the land lease could not be extended, and this will have a far-reaching effect. I'd like to hear from the administration about this issue. If I were a small owner, I would be worried. These provisions were not existent in the New Territories Leases Extension Ordinance Cap 150 in 1997. Many owners in Hong Kong are actually overseas right now. So, how are you planning to step up publicity so that for owners living in overseas, they will also be informed of this bill? On the last point, for non-extension list, in clauses 10 and 11, it is possible that you can make a non-extension list inclusion or removal notice. But for clauses 10 and 11, you did not specify the circumstances in which the government will exercise this discretion. You only state that in rare circumstances, but you did not specify in which circumstances you would do so. I'd like to seek clarifications from the administration. Administration, please, Ms. Doris Ho, Permanent Secretary. Thank you, Chairman. Thank you, Ms. Doreen Kong. I'll start with the land administration perspective, but I will also seek help from the DOJ in relation to the drafting aspects. First of all, on extension, our spirit is to, we hope that the land lease will be carried forward. In other words, we will not introduce unnecessary provisions or clauses. Just now, the Deputy Secretary also explained. in our PowerPoint slides, in the 8th slide, for the newly added provisions, they are to empower the government to re-enter part of the lots in the event of non-compliance with lease conditions. The government can make sure the landowner will comply with the town planning ordinance and the buildings ordinance, and that only parts of the lots will be re-entered instead of the entire lot or building. So when a building does not comply with lease condition or has any illegal structures, then we will not extend leases. This will not be the case. When we refer to this in the past, multi-story buildings express concerns, not least industrial buildings. In some cases where the land use does not quite match the actual situation, we will consider not extending the lease. In most cases, we will not do so unless a major public concern is involved. So our spirit of the legislation is, as I said, unless major public interest is involved such that the government considers it is not suitable to extend the lease, we will extend the lease. For example, in lease breaches or in illegal structures, these situations should be dealt with separately. For example, through the enforcement of land leases or through the follow-up by the Buildings Department in accordance with the Buildings Ordinance. Well, can I still answer the remaining questions? Sure. Ms. Doreen Kong's another question is how we can promote this legislation to overseas owners or owners of Hong Kong properties that are right now overseas. Well, owners, both overseas and local alike, should be informed of the legislation. We'll prepare video clips, short clips of 30 seconds, we'll disseminate the information in these clips on social media channels. We'll also step up publicity on our websites, social media platforms, to step up publicity and promote the information. We will also update the Lands Department website so that important information can be disseminated in a one-stop portal. So landowners and investors will also be informed of the latest situation. Mr. Rincon also asked about clauses 10 and 11. That is, under what circumstances will the lease be not extended? Well, that is indeed a rare situation. One example is while the lease is a special purpose lease, SPL, but the Lands Department thinks that this is an SPL, but the owner lodges an appeal. When the Lands Department considers the appeal afterwards, changing the lease to an ordinary lease would be appropriate. That is the lease under our bill. That is, the lease can be extended through legislation. In the extension notice or the non-extension list, we will have to follow it up. In other words, if some leases, that is SPL, are changed to ordinary leases and we will extend leases, there is follow-up work that we'll have to do. We'll have to put it in the extension notices, and in some cases The non-extension list will also have to be updated. Thank you.
一個好簡短。
Sorry, I have a short supplementary answer to give regarding clause 13. Whether it is the case that the conditions have to be met before we will extend the lease. It's not the case. After the extension of the lease by clause 13, the conditions will be entered into a new lease, thus requiring the relevant owners to comply with the town planning ordinance and the buildings ordinance, and the government may take enforcement action under the lease. It may be on the government land or the landlord in general or individual units. So essentially, we have included a clause for compliance with the relevant ordinances and empowering the government to take enforcement action under the lease. Next, Dr. Johnny Ng. Thank you, Chair. I want to talk about the public interest consideration part mentioned. If there are public interest considerations, the leases may not be extended. What would public interest consideration involve? Do you anticipate any leases that you know of that may not be extended due to public interest considerations? Regarding national security, as said in the PowerPoint presentation, there is an approval requirement applicable to properties of consular missions and representative offices of international organizations. What is the government's criteria on the delineation of such properties? How many lots or buildings do you expect that there are for such properties? Thank you. Thank you for your questions. Regarding the public interest consideration part, when considering whether to extend leases and the public interest considerations concerned, let me give an example. Some people would often ask, if there are breaches of the lease, would it be a public interest consideration? We actually have a very high threshold for that. When we propose that there is a public interest consideration, there is a very high threshold. For agricultural land in the new territories, according to the leases, they can only erect small structures. For example, if the owner erected a domestic structure on the lot, and worse still, rent such units to other parties, the government would, of course, first follow up on the case, take enforcement action, asking them to remove the structure. If the owner, despite repeated actions and warnings by the government, decides to not rectify the issue, we would potentially consider this to be a public interest consideration. So as I said, it is quite a high threshold. As I said earlier, the high threshold is due to the fact that any lease breaches should be dealt with by enforcement action, not lease non-extension. So unless there are serious breaches unpurged despite repeated warnings, we then may consider this to be a public interest consideration. We do not have accurate figures on hand on how many leases that may potentially be not extended, but the Lands Department definitely has such figures on enforcement action, and such figures will be taken into account when considering whether to extend the leases. As for what lots are related to consular missions and representative offices of international organizations, there is actually a specific criteria. One is a consular post. There are 63 of such properties. We have 8 international organization lots in Hong Kong. What kind of international organizations are them? For example, the EU office in Hong Kong and the IMF office in Hong Kong. So these are the 2 examples. We would also have to consider the property concerned, the foreign-related entity owning the property. What are they using the property for? If it is to be used as a consular post or residence for mission head or staff members, or the offices of the international organization, only if such properties are of these, then they would be subject to the approval requirement by the OCMFA. That is the Office of the Commissioner of the Ministry of Foreign Affairs of the PRC in HKSAR. So the government will most likely publish an extension notice no less than 6 years before expiry, but they would have to obtain approval no less than 60 days before expiry from the OCMFA. We do have some figures, but they are not comprehensive because these are figures from internal discussions with the relevant consular missions and representative offices of international organizations. We have such figures because the relevant staff members have applied for exemptions under certain conventions and ordinances. But as I said earlier, these figures are not comprehensive. We have approximately 10 lots involved, I believe, and there are individual units, 100 individual units in multi-story buildings. We have 8 members who have yet to ask questions. Let me read out the order. Ms. Nixie Lam, Ms. Carmen Khan, Mr. Lau Kwok Fan, Mr. Tony J, Mr. Lam Tan Kang, Mr. Louis Lung, Dr. Kennedy Wong, and Dr. Wendy Hung. Ms. Nixie Lam, please. Thank you, Chair. With the new mechanism, leases can be extended in a streamlined manner, so I welcome the legislative amendments. In May of last year, when giving a reply to panel members, there will be an appeal mechanism for those owners who have had their leases included in the non-extension lists, and the appellants will be able to give some grounds. Do you have something in mind for the appeal mechanism, perhaps a framework? I understand that some promotion will be done, and some foreign chambers of commerce and consular missions may have misunderstood the legislative amendments. They may be those that have their grounds or those that are unsubstantiated. But I think we should make sure we make clarifications when necessary. If you only publish information on the Lands Department's website, I think it may be too passive. We should be more proactive, perhaps adopting some special channels or be more drastic. Otherwise, it may be subject to smearing. I believe we have seen many of such cases in 2019. So with something that may be hard for the public to understand, it requires more promotion from us. Thank you. Permanent Secretary, please. Thank you, Ms. Nixon, for your questions. We do have an appeal mechanism in mind for leases that are decided to not be extended. We will have an appeal mechanism for these cases. The Lands Director of Lands was to make such decision, so we would propose that the appeal mechanism be implemented via administrative means. Our preliminary framework is that once a non-extension list has been promulgated within 1 year, we would allow for the owners of the relevant lots to lodge an appeal with the Lands Department. We plan to implement the appeal mechanism in 2 tiers, but both tiers will be within the Lands Department. The first tier would perhaps involve a D2 official dealing with such appeals. Once such appeals are received, we plan to resolve the appeals within a reasonable time frame, that is perhaps 6 months. If the applicant feels aggrieved after rejection of such appeal, we could have a second tier that would deal with the appeal. We are planning to have perhaps the Deputy Secretary for Development deal with the appeal. We will issue the relevant guidelines on the Lands Department's website in future, or perhaps other channels. Regarding the properties of consular missions and representative offices of international organizations, let me emphasize this. This approval requirement concerned is not new. It was proposed in June 2022 by the OCMFA, requiring consular missions and representative offices of international organizations, that is, foreign-related entities. They must not acquire or dispose of properties used as chancelleries or residences of mission staff members without the prior consent of OCMFA. We are just implementing the requirements put in place by the OCMFA. This is not something new. After the introduction of such requirements, we did monitor the feedback of the relevant bodies. We have made sure the bill is given to the relevant consular missions and representative offices for their consideration, and there are consular missions that contacted us asking about the detailed arrangements of the legislative amendments. We would say that this is not something new. As I said, these requirements were put in place since June 2022. These are not new at all. And the we haven't received that many questions from the relevant bodies. We will continue to maintain close liaison with the OCMFA, however, to see if we need to better explain our legislative amendments to the relevant bodies.
Ms. Carmen Khan. Thank you, Deputy Chair. I speak in support of the proposal by the administration, that is by way of legislation to introduce a new mechanism for a more effective and streamlined manner. As mentioned, some 24,000 lots will expire on the 29th of June 2047, and there will even be 300,000 lots that will expire on the 30th of June 2047. The Blue Bill is a brand new legislation. It is not an amendment. I'd like to hear from the administration, that is to provide further documents in relation to the new territories leases extension ordinance cap 150. In paragraphs 4 and 7 back in 1997, the land policy provides the sole discretion of the government. Just now, the administration said that involving commercial or residential properties, these pieces of land will be extended unless public interest considerations are involved. But I think that given this factor, the sole discretion of the government is needed. And if any pieces of land falls within the non-extension list, we should give the opportunity to the owners to state their own grounds. I'd also like to hear from the administration if there is any discrepancy between the land use and the actual use. It is made clear if a piece of land is of public use, a compensation will be disbursed before a piece of land will be extended. This is a new mechanism. In a PowerPoint presentation in page 7, there is an appointed date. In Yaotimeng, there will be 50 relevant lots that will expire. Are we aiming at rounding all these up by the end of 2024 so that we will have enough time to make the non-extension list? Should there be further updates, the non-extension list will also be updated accordingly. And how will the public know the properties will be, the properties will expire within 6 years. Within 6 years in the relevant pieces of land? Do they have to consult the administration or the landowner? In paragraph 13, it was mentioned that exception will be made for leases expiring in less than 6 years' time, with extension notices and the corresponding non-extension lists to be published on the appointed date. Thank you, member, for the question. On 1997 land policy, one of the basic principles, as Ms. Carmen Khan mentioned, the government has sole discretion as to whether or not a lease could be extended. In 1997, the land policy back then also touched upon it. That is for a term of 50 years without payment of an additional premium but an annual rent equivalent to 3% of the prevailing rateable value of the property at the time of assessment of annual rent shall be charged. We can provide the land policy in 1997 to the Secretariat, and the Secretariat can pass it around members. For example, if there is a piece of land, if the government has a plan to resume it for development in the future, and if it will expire soon, when the government resumes it for development in the future, it will not be a consideration as to whether we will extend the land lease or not. If the government needs to resume the piece of land for development, the government still needs to act according to the Land Resumption Ordinance. In other words, when the government resumes a piece of land, compensation will be paid. The government will not resume the piece of land and develop it without any compensation. This is not our policy intent at all. As for point number 3, let us go back to the PowerPoint slide number 7. We do want to have a regular mechanism in the future. That is, 6 years before the expiry of the land lease, the government will have to make a gazette informing the landowner as to whether or not the government will extend the land lease. So when can the 6-year arrangements be put in place? When the land lease is going to expire in the year 2031, this will be applicable. That is, by the end of 2024, we'll proceed with the land lease work accordingly, because the land leases will expire in 2031. So if the government is not going to extend the land lease, the piece of land will be on the non-extension list. This is the regular arrangements that we would like to put in place. Starting from 2025, June to 2030, for the land leases that will expire between this time frame, we will not be able to comply with the 6-year arrangements. But we will also inform landowners whether the land leases could be extended as early as possible. That is, on the effective date of this piece of legislation when it is passed in the Legislative Council. On that very day, we will publish a notice, non-extension list and the extension list. That is to handle the land leases that will expire between June 2025 and 2031. In other words, we can deal with these land leases as soon as possible. After this piece of legislation is passed, how are we going to make arrangements with Gazetted? This is our planning. On liaison, this is important as well. Based on our explanation just now, if the land lease will expire in or after 2031, the government will make the Gazetted 6 years before the expiry. If it is earlier than 2031, however, we'll try to make the Gazetted in the middle of this year. That is when this piece of legislation is passed. We need to explain clearly to the public. That is because it depends on which category their cases fall into. On social media platforms, on the website of the Lands Department, we will disseminate this message in a systematic manner. Thank you. Mr. Lau Kwok Fan. Thank you, Deputy Chair. I do agree with this bill, and I think we need to move with the times. The existing practice is quite old back then. The earlier we proceed with this piece of legislation, the more stable we can help the market to be. This will be conducive to the market and its development in the future. I have some technical questions. Whether new land or extension of new leases, I'd like to ask about adverse possession. I always advocate the fact that there shouldn't be any adverse possession in this day and age. One does not have the ownership in the case of adverse possession. One only has possession. If one cannot have development on a piece of land and he or she is aggrieved, what about the owner of the land? Does he or she still exist? Will the ownership of the adverse possession be for good? That is the right to possess and to use that piece of land. In some cases of adverse possession, some owners are no longer here. They may have passed away, they may have gone to other places, and in fact, there are quite many these pieces of land in the new territories. They've gone to waste. Whether the buildings department or the lands department, the temporary waivers need to be signed by the owners of the pieces of land. If they are not signed, these pieces of land are left idle. They've gone to waste. For the renewal of lease, I've come across many of these cases. There are quite many cases of adverse possession in the new territories. They can only preserve their status quo. Development or improvement is not available. So I'd like to know if there is any change in the ownership or the right of possession. What is the current situation? Thank you, member, for your question. When we handle the extension of land leases, we are required by law to deal with the owner. That is on the register of the lands department. The lessee or the owner of the pieces of land. That is, we need to refer to the written record of the lands department. Then we'll get in touch with the lessee or the owner in order to discuss the land leases arrangements or the extension of land leases arrangements. As members said, if there are any disputes over the ownership of the land, for example in the case of adverse possession in the extension of land leases, we'll not handle the disputes in relation to the ownership of the piece of land. As we only discuss or deal with the lessee of the land in relation to the extension of land leases, we do not handle any disputes as to the ownership of the piece of land. In case of any disputes, the owner in the paper form and the owner of adverse possession can continue to deal with the issue. So basically, we do not effect any change in the case of adverse possession. Simply put, if the ownership has already passed away, how will we deal with the situation? Likewise, by way of legislation, we refer to the Register of the Lands Department. We extend land leases with the person on the register. That person does not have to sign any document with us. Even if that person has already passed away, that does not matter. In case of a land transaction, if the owner of the land has already passed away, in accordance with existing laws, it will be dealt with accordingly. The land lease extension will not change the situation. So Mr. Lau's question is very good. By way of legislation, we extend land lease. We do not want to change the land status. We only deal with land lease extension. We do not handle any dispute of the ownership of the land. So the land leases and other factors would be carried forward.
这个
But I want to ask, you mentioned I mentioned three scenarios, and if the owner has passed away, that would be one thing, and if the owner chooses not to extend the lease, what will happen? Well, in fact, I think this is mentioned in the paper, and I think they have mentioned that earlier. But I'll let the Permanent Secretary answer that. I think it would be a very rare case. In fact, for the new territories lease extension ordinance, when it came into effect, no one chose not to extend the lease, but we have tried to be comprehensive and included the scenario in the legislative proposals. Should the owner opt not to extend the lease, the lot will go back to the government. Next, Mr. Tony Jie. Thank you. I support the legislative proposals. I want to follow up on a few points made by other members. If you think enforcement powers are to be given to the government, some owners may be dissatisfied and choose not to extend the leases. Well, I think there may be such cases. It may not be as rare as you think. As Mr. Lau Kwok-fan said, the owner may be one person on the register, but the occupants are different people. The owner does not have the power to do so due to the occupants being there, and for the owners, they may think that having this land is like having none at all. So they may indeed choose not to extend the lease involved. So I think the administration should note that there may be such possibility. Regarding the subdivided lot basis used, I understand some colleagues said that and raised some questions about that, and you said that the legislative proposals would incorporate some conditions in relation to the compliance of ordinances. I definitely support that because they are to be complied with. But as another member proposed, for the Red Hill Peninsula, would you consider the breaches to be serious? And in fact, there may be series that are not even identified just yet. So if you extend leases with the relevant landowners, would it constitute an approval of their conduct? Would that be a problem for the public to understand this situation? As unauthorized building works are definitely a breach of the lease, I hope the administration would elaborate on this. If there are many of such cases of breach, it will be hard for the administration to deal with. I believe there are many compliant owners out there, but if there are a significant number of cases where the owners would breach the lease, the administration should think about the perception of extending the leases given to the public. Also, regarding paragraph 16 of the paper, it is said that the Director of Lands will be allowed to publish a non-extension list inclusion notice if necessary. Would there be a time limit for that? Because if there is no time limit, again, this will be made uncertain for the landowners. Or would you have some other measures implemented to assure the landowners that there will still be certainty with the relevant arrangements? Regarding conditions for safeguarding the government's enforcement powers, this is mentioned in paragraph 17. There is the applicability of the re-entry clause that is present in existing leases clarified. I want to ask, would this complicate matters when enforcing the relevant ordinances, causing a burden on officers? In my understanding, if people think it is very hard to enforce this clause, would the administration consider streamlining the procedures to make sure there is effective enforcement? For example, if many provisions of the relevant ordinances are breached, would you have one single department, that is the lands department, take enforcement action, or would you leave it to the different departments to take enforcement action, which, as I said, would complicate matters and would cause the process to take much longer? We, of course, want to make sure there will be deterrence. Thank you. Thank you, Mr. Jay, for your questions. Regarding serious breaches of the lease, under what circumstances would that constitute a public interest consideration to not extend the lease? We think one single breach wouldn't make for that. As I said earlier, when we take enforcement controls, we would give chances to owners to rectify the relevant breaches. We think a chance must be given first. If we have given them multiple chances, yet they have chosen not to rectify the breaches despite the repeated warnings, we would say this situation to be the serious breaches unpurged despite repeated warnings. We may consider citing this to be a public interest consideration when considering whether to extend the lease concerned. I think it would definitely depend on the actual circumstances. I will not give specific examples of developments, But before, there were examples of encroachment on government land. After the Lands Department has issued warning letters, some owners complied with the law and rectified the breaches as soon as possible. There were owners who practically ignored such warnings. If repeated warnings are issued, and despite that, breaches are not rectified, we will consider this to be a public interest consideration when extending the lease. In paragraph 16, regarding the non-extension list inclusion notice, whether a reasonable time limit will be imposed. As I said earlier, it will only happen in one remote scenario where a lease is reclassified or modified from an SPL, special purpose lease, to an applicable lease after the relevant notice and non-extension lists have been published and the Director of Lands decides not to extend it. Well, we would say that the notice will be issued as soon as possible. We would most likely have the relevant list or notice published along with the reclassification or modification of the lease the notice of that. Regarding breaches of the relevant ordinances, we will ensure that we will implement, if necessary, more measures to ensure effective enforcement after the incorporation of such conditions in the new leases. If necessary, the government may re-enter the land or the part of the land that is the property. If there are serious lease breaches in only part of the land, I would emphasize that the government may re-enter only that part of the land to minimize the impact caused to other landowners. So we just want to incorporate such conditions in the legislative proposals to make sure they are entered into the new leases. Well, I heard Mr. Tony Tse say that for cases of adverse possession, some owners may not be able to deal with the breaches themselves. Would the administration help with that? And when you extend the leases of those that have serious breaches or lease breaches in general, would that cause a public impression that the government is allowing for such breaches to happen? Well, thank you. If all circumstances are considered and the leases are extended despite the relevant lease breaches, it does not mean that the government allows for such breaches. The government will continue to take enforcement action with other enforcement measures. Regarding the first question about adverse possession, the existing owner or lessee cannot deal with the relevant breaches or occupation, illegal occupation. I would say that the government would extend the lease with the owner. If the owner chooses not to extend the lease, the piece of land would go back to the government. Even if there are adverse possessors, that is the occupants staying there, when the piece of land is returned to the government, the occupants will no longer be allowed to stay there. Thank you, Mr. Tony Tay. I want to ask more about the part about the government allowing for such breaches. Even if enforcement powers are given to the government, why is the government not choosing to make use of such enforcement powers? In fact, as said earlier by my colleague, for clause 22, if there are breaches of covenants and conditions, it does not mean that we would give up on our powers to take enforcement action. You can follow up on the second round. Thank you.
Yeah.
Mr. Ambrose Lam, thank you. Well, I have to declare, I do provide services in land transactions. Out of historical reasons, I support the land lease extension. There may be different periods of land leases. So for the 50-year extension, different pieces of land have different expiry dates. Probably it's difficult, but I still need to ask you whether this is possible. For example, in 2047, is it possible to standardize the expiry date so that some pieces of land will expire on a particular date en bloc? This will be clear. This is my first question. Regarding the second question, that is for the acquisition of properties by foreign-related entities when they purchase a place or piece of land. They are not sure whether the OCMFA will give the consent. There are a host of factors at play in land transactions or in land sales. They are not sure whether the OCMFA will give their consent. The property market is subject to many factors. There are uncertainties. For instance, sometimes the land leases may be shorter. The term of the land lease will also have an impact on the decision. When foreign-related entities need to make an application with the OCMFA, is it possible to obtain an advance approval? This will give foreign-related entities peace of mind. For example, a certain price can be reserved. In the case of adverse possession, will the extension of land leases affect the period? There may be many of these cases in new territories land. Is it possible to make it clear that this will cause no impact on the interest of the landowner of the piece of land which has been adversely possessed? So to some landowners, the piece of land does not belong to the owners, so anyway, they won't do anything about it. Mr. Ambrose Lam, regarding your second question, do you mean the consulate staff members purchase properties themselves? Well, I mean foreign-related entities. Permanent Secretary. Thank you, Mr. Ambrose Lam, for your questions. Will we consider standardizing the extension of land leases? Well, that is, what is the reason for not standardizing the land lease extension? Well, we put forward this legislative proposal because of the 1997 land policy. Different land leases have different land lease expiry dates. Despite the 50-year period across the board, it's still unavoidable. The different land leases will have different expiry dates, and this is the land policy back in 1997. It serves as a reference. That is how we look at the situation. Your second question concerns the purchase of land by consular missions or international organizations. That is when land lease extension is not possible. That will cause a major impact on the value of the piece of land. So your suggestion is, in purchasing the properties, the OCMFA will give a pledge or an undertaking that an extension will definitely be offered. Well, this is a diplomatic matter, and the Ministry of Foreign Affairs will call the shots. The Hong Kong SAR government is simply responsible for implementing their instructions. So, for the arrangements introduced in June 2022, the Ministry of Foreign Affairs does want to retain flexibility for itself. That is, near the time of land lease expiry date, the OCMFA will have the decision whether or not to grant the extension of land lease. With the flexibility, this is important to their handling of diplomatic matters. This is their design, in my opinion. Well, I don't want to ask over time, but such being the case, it would be best for foreign-related entities to look for land leases that start in 1999. Otherwise, it will be very complicated when they have to seek consent from the OCMFA. Sometimes purchasing properties or land takes a very short time. If you incorporate a provision that the transaction is subject to the OCMFA, it will be very uncertain and it is quite difficult. Well, I noted your concern or suggestion, but based on our experience, if some consular missions and international organizations have to seek consent from the OCMFA actually replies within a reasonable time frame. And in almost all cases, the OCMFA exercises its power reasonably. So going back to the case of adverse possession, after the extension of land leases, does the period of 60 years have to be counted from scratch? No, this is not the case. Let us go back to this period behind the land lease extension. The land lease will be preserved and it will be carried forward with the addition of some minor enforcement powers or provisions, and the land lease will be extended by 50 years. So under the existing law, Clause 12 has already specified For the extended land lease, this will not give rise to a new land lease. It just involves the addition of some enforcement provisions. Well, I think lawyers tend to be quite long-winded, but in the interest of time, probably Mr. Ambrose Lam can ask in the second round. We still have other agenda items to proceed. Chances are that we can't move to clause-by-clause scrutiny. But I'd like to give members more time to ask about policy issues. Mr. Louis Long. Thank you, Chairman. Handling the extension of government leases by way of legislation, this is good, and I speak in support of it. I have two questions. In the PowerPoint slides, in slide number 1, one of the principles is the land policy in 1997 will be kept unchanged. Then in slide number 6, the applicable period applies to all land leases except short-term tenancy and special purpose lease. This is contradictory. The 1997 land policy is a Bible to me. I go by the land policy in 1997. This is closely related to my career. So on the handling of the SPL, special purpose lease, the handling is exactly the same as all land leases without a right of renewal, barring 4 situations. 1. Recreational purposes. Petrol filling stations and public utility operators. I'd like to know why SPL is also involved in land leases without a right of renewal. This is my first question. Moving on to slide number 7. The extension notice. There will be at least 6 years before the notice is issued. I'd like to ask the administration, have you consulted the Hong Kong Association of Banks in relation to loans, mortgage, or guarantee? Will this cause an impact on the decision of loan approval? 2 questions, Permanent Secretary. Thank you, Mr. Louis Long, for your 2 questions. For the first question, in relation to the land policy in 1997, special purpose lease SPL is regarded as different to other commercial or residential leases. This time round, we don't handle SPL by way of legislation. The reason is that for land falling into special purpose lease, these pieces of land are given to some organizations for some particular policy intent. For example, bus stations, public utility operators, or even more commonly, some pieces of land earmarked for education, welfare, religious purposes. These pieces of land are SPL. There's a policy objective behind it. So every time before the land lease is extended, we simply can't deal with it by way of legislation like the current proposal. We do need to contact the relevant policy bureau. That is, before the extension of the land lease, is this piece of land still required in order to support the existing policy objective? So we can't handle the extension of land leases by way of legislation. We do need to contact or liaise with the policy bureau. We need to have internal communication. So this is different from the commercial, industrial, or residential land leases. Moving on to the second question of Mr. Louis Long. "6 years before the expiry, will inform the person involved. We have already contacted the Hong Kong Association of Banks or the Hong Kong Institute of Surveyors. Well, they think the longer the better. But how long? Their suggestion is as long as 10 years. But the Hong Kong Association of Banks said that it would not affect the value of properties. Rather, if the government does not extend the land leases, they'll need some time to deal with the loan arrangements with the borrowers. We've consulted them on the period involved. The Hong Kong Association of Banks can still deal with situation where a land lease is not extended. Currently, when they set down the mortgage agreement, they do have a provision. That is, if the government extends a land lease, you can reject. And if you do reject, the bank may require you to settle the loan in no time, or you will have to put up more mortgage. So previously, the arrangement was that you will have to make the Gazetted 3 years before. Right now, the existing proposal is 6 years. We have already made reference to the ordinance back in 1988, and that is the New Territories Leases Extension Ordinance. The period was 9 years. But the ordinance enacted in 1988 had a different historical context. Back then, it was about reunification with the motherland, and that involved 2 different governments, so the earlier the better. That is exactly why we changed from 3 years to 6 years, and we consider it appropriate.
Let me just have a short follow-up. Regarding the interpretation of the 1997 land policy, I have a different interpretation from the Permanent Secretary. If it is said in the 1997 land policy, if the special purpose lease is to be used for the same specific purpose, the government would have sole discretion on whether to extend the lease for a term of 50 years without the payment of an additional premium. 4 exceptions were included. The other wordings, for example, non-extendable lease, that would be exactly the same. So I would disagree with the interpretation of the Permanent Secretary. I just want the Secretary to note what I said. Thank you. Well, we have another agenda item today, and we will draw the line here due to time constraints. I think it is appropriate because that will give us more time to talk about policy matters, and we will not go into clause by clause examination today. Next, Dr. Kennedy Wong. Thank you. I would like to declare an interest because the law firm that I work at would deal with property and land matters. Thank you. The administration talked about promoting the relevant arrangements, but I didn't know of any plans to liaise with real estate agents. Indeed, real estate agents are under the purview of Housing Bureau, but these are all interrelated. If incompleted units are to be sold, they would be under the management of the lands department. Will the lease, whether the lease is to be extended, will it be included in the promotional materials of the relevant residential developments? Because that would definitely be an important piece of information for property buyers. For second-hand flats, most of them are sold by property agents. They have standard agreements for sale or temporary agreements for sale at the moment. It would specify disclosure requirements for unauthorized building works and the leases being suspended. So, would you consider making it mandatory to include the piece of information on whether the lease has been extended? Otherwise, property buyers may find it hard to find out. I, as a professional, still had a hard time grasping the relevant legislative proposals. To ensure buyers' interests are protected, I think we should incorporate such information in the promotional materials of residential developments. Thank you. Doris, please. When we worked on the bill, we did consult the estate agents authority, but I do note the member's suggestion. When citizens are thinking about purchasing a particular flat, they would consider the remaining lease term and whether the lease will be extended. So we'll take note of your suggestion and see if we will add the relevant information in the promotional materials as well as the temporary agreement of sale. We will, after the passing of the bill, liaise with estate agents authority to see if we can reach out to the frontline agents to brief them on the legislative the provisions in the bill so that they can better deal with any inquiries should they encounter them. Next, Dr. Wendy Hong. On 30th of June 2047, we will have leases of many lots expiring, so I do support the legislative proposals. I also support the relevant encumbrances, interests, and rights under the original lease to be carried forward to the new lease. It would simplify things because I believe there are other mechanisms to deal with the other parts. As said, the interests, encumbrances, and rights will be carried forward, but there will also be an incorporation of conditions for safeguarding the government's enforcement powers. Would these two be conflicting? Would you be able to incorporate the relevant conditions without altering the original terms and conditions of the leases? It is also said that for some lots that have serious breaches, leases may not be extended. It is said that should that happen, the piece of land will be returned to the government. Is it the case that it will be returned to the government without compensation or with compensation like it is under the resumption ordinance? It is just as Dr. Wendy Hong said, should there be serious breaches, the government can't re-enter the land in the existing lease. But of course, if there are restrictions imposed due to serious breaches, the relevant landowners cannot sell the pieces of land. Thank you for the questions. For the original lease, the interests, encumbrances, and rights under which will be carried forward to the new lease, we will also incorporate conditions for safeguarding the government's enforcement powers, whether these two are in conflict with each other. Let me first give you some background information. The conditions that we plan to incorporate are very basic, and in some post-1997 leases, we have incorporated these conditions. So this is not something entirely new. The post-1997 leases would have such conditions, so we have only included such basic power conditions in the legislative proposal. As we are doing this through legislative proposals, we do not consult the owners before we extend the lease. That's why we want to minimize any chance of potential conflicts arising. Would that involve technically modifying the lease? Technically, it wouldn't be. As I said earlier, we have clause 12. What does it say? It says that the extended leases are not new leases. They are just original leases with some new conditions incorporated. If the leases are not to be extended, the pieces of land will be returned to the government, whether the government would have to pay any compensation. We don't have to pay any compensation. In fact, we have, as I said earlier, 25 lots that have expired. And out of the 25 leases, 22 have been extended. 3 were not. 1 was a lease modification for redevelopment in lieu of extension on original terms. 2 others were not extended because the relevant owners could not be found. So when the leases expired, the pieces of land were returned to the government. The government did not have to pay any compensation. Essentially, it became government land right away upon the expiry. Thank you. Mr. Dennis Leung. the leases will expire. If we are to adopt the conventional mechanism, we would need much resources. So I would support the relevant legislative proposals. But for leases that do not have serious breaches and they have mortgages on them, I would agree that a simplified extension would be in order. But for those that have serious breaches and refuse to rectify these breaches despite repeated warnings by the Lands Department, I would consider this to be an issue because the breaches are not rectified. Not only that, the landowners may have encroached on government land. They are essentially benefiting from such breaches. The government does not do anything or does not require them to rectify the breaches. It definitely gives off a wrong impression to the public that the government is essentially allowing for this to happen. I think the government should take a tougher stance on this. I have two questions in particular. How many of the leases have no conditions at all? Where are these lots located? What are these lots being used for? When the proposals come into effect, only conditions for safeguarding the government's enforcement powers will be incorporated. There are no additional conditions that are to be imposed as I know of. How will you ensure there will be appropriate controls for such lots? For some lots that are very old, that is before the Sino-British Joint Declaration, they will need to pay government rent. And now if the lease is to be extended, they would be paying government tax, and now they would have to pay an annual rent, essentially a government rent equivalent to 3% of the prevailing rateable value. Would that be higher than the government tax or would that be lower? Thank you.
Permanent Secretary, thank you, Mr. Leung, for your question. I'd like to state again how we deal with non-compliances of lease conditions. Well, actually, we are on the same page regarding serious breaches, and when the government has already required rectification, but then despite repeated warnings, the relevant personnel still does not comply with our orders, we think this is actually involved in, this involves public interest considerations. In most situations, we will extend land leases, but we still need to retain some flexibility with discretion. This is exactly when we need to deal with situations involving public interest considerations. We'll face these situations seriously and we'll exercise our discretion as to whether we'll extend their land leases. When there are cases in which the personnel does not comply with our ratification requests despite repeated warnings, it still does not mean that the government acquiesces to these breaches. In other words, in accordance with, for example, buildings ordinance or occupying government land will take enforcement actions. In terms of this, we go along with Mr. Dennis Leung. Whenever public interest considerations are involved, we will consider not granting the land lease extension. Regarding land leases without any restrictions, that is, the development parameters or the land use are not involved, the period is as long as 999 years. From our information right now, there are some 4,000 odd land leases at present. So you also asked about how much is paid more when the requirement is 3% of the prevailing rateable value of the property at the time of assessment. According to the New Territories Leases Extension Ordinance enacted in 1988, these pieces of land have been paying 3% of the prevailing rateable value of the property at the time of assessment of annual rent. Most of the pieces of land are the land leases entered into before 1970. They are mostly in Kowloon Peninsula or on Hong Kong Island. After renewal or after extension, they will have to pay 3%. Let me give you an example. Port Fulham Gardens. In 2006, land leases were extended. In one of the units, before extension, Permanent Secretary, I don't think you have to delve into the details of these cases. You just need to tell us that you will use the set approach to deal with these cases. However, if members would like to seek more information or case studies from the administration, I don't think I need such detailed information. Just to supplement, using the example just now, that is Port Fulham Gardens, before land lease extension, the unit was paying hundreds of dollars, whereas after extension, one has to pay $4,000 to $5,000. Mr. Andrew Lam, I do go along with the policy goal or policy intent, but I do have some legal questions to ask the administration. Whether land leases will be extended, the government plays two roles. One, as the landowner of the land, whether the government will extend the land lease, this is an administrative decision. But when we draw reference from the New Territories Leases Extension Ordinance enacted in 1988, using legislation to deal with the extension of government leases, this is something good. In the past, many matters were set down very clearly in the ordinance. There wasn't any discretion given to the administration. What was precluded, what was excluded, all of those were already set down in the legislation. However, in this legislation, flexibility has been given to the administration to change the extension list or the non-extension list. I need to get things clear. What is the legal support for this? It's not clear here. The bill this time round also covers the new territories. I'd like to focus on period. The resumption of the land in new territories will go until 2047. Will this bill cover any land that goes beyond 2047? If so, in terms of the dates, there may be contradiction. How should it be interpreted in law? Permanent Secretary. Thank you, Mr. Andrew Lam, for your questions. On your first question, our bill is based on the land policy in 1997. Basically, it should reflect the land policy in 1997. Afterwards, we'll send the entire document to the Secretariat, which will then be passed around among members. For land leases that will expire after 1997, the government has absolute discretion as to whether the land leases will be extended. Well, excuse me, Permanent Secretary, seldom do I interject, but I'd like to ask. You've made it very clear in the documents. That is the land policy in 1997. The policy itself is not a legal basis. So, I asked very concretely, what is the legal basis upon which you will exercise the discretion or retain the discretion in your bill? That is different from the handling in 1988. The handling in 1988 was very clear. There wasn't any discretion at all. Well, for non-compliance, these are not discretion. When there is non-compliance, resumption is possible. Mr. Andrew Lam mentioned discretion. That is the negative list. I am concerned about the negative list. The reason why I needed to introduce the land policy in 1997 is that the ordinance in 1988 was not about the land policy in 1997. Back then, it was to deal with many pieces of land that will expire en bloc. So the starting points are actually different. Our bill right now is based on the land policy in 1997. The land policy in 1997 states clearly that the government has discretion as to whether the government will extend the land leases. That is exactly why we need to reflect the design in the bill. We need to tell members of the public that for most of the land leases, they will be extended, but there are still chances that some land leases will not be extended. That is why we need to have non-extension list or notices informing members of the public that what pieces of land will not be extended in relation to their leases. In relation to whether some period will go beyond 2047, many land leases at present or for new land leases, they will expire after they will go beyond 2047. For newly approved land leases or for extension of land leases, they are different issues. We can follow up later on. Well, the question and answer session comes to an end right now. We'll continue with the question and answer session in our next meeting. Members can follow up on your questions, or you can also ask new questions. Thanks for coming to the meeting today. I am liaising with the Secretariat. We'll decide on the next date. A Chinese New Year break is around the corner, so the Secretariat will keep members informed of the next date of the meeting. Any other business? No? Meeting adjourned. Thank you, members.